Welcome to the first episode of Mike's Jurisdiction, hosted by, yeah, you guessed it, me. I'm Mike. And this is my jurisdiction. This is going to be a podcast or show talking about the law, past cases, current cases, really anything that I want to talk about. A little bit about me. I am a 2L law student, and my current passion is criminal law. So you can probably assume that most of the cases that we're going to talk about are going to involve criminal law. Just because for me, I think it's some of the most interesting aspects of the law. And also, I feel like it's some of the most useful aspects. Some of the things that we might not think about in every day-to-day life that are extremely important to think about. Because, you know, shit can get real very quickly if you're not mentally strapped. So what we're going to talk about today is what constitutes a crime. What's a crime? What makes something illegal, right? I think whenever you hear the words, illegal or crime, you're like, oh, murder, robbery, assault, something like that. But these legal heads, these academics, okay, they put a lot of thought, a lot of effort into what is actually a crime. And there's two things that essentially have to go on to make something a crime. You have to have the criminal act, you have to actually do something wrong, and you have to have the criminal intent. There's actus reus, which is the criminal act, and then there's mens rea, which is the criminal mind, essentially criminal intent. You have to do something wrong, and you have to know or intentionally do it wrong. Now, there's different versions of criminal intent, okay? And I'm not going to get into that right now, okay, because this entire show is going to be about what makes a crime. So we're going to first talk about the criminal act, actually doing something wrong. And like I said before, whenever you think about criminal act, doing something wrong, everyone's always like, oh, assault, murder, robbery. Like, it's very obvious when you're doing something wrong. But a case that I learned in law school, which is, it's honestly kind of a ridiculous and funny case, kind of helps you categorize and understand what a criminal act actually is. So we're going to talk about this case, Martin v. State, okay? So Martin, who is a defendant, was arrested at his home. So the police came to his home and arrested him. And then what they did is they took Martin, okay? They put Martin in the back of a police vehicle, okay? And then he was then separately charged for being drunk and using loud, profane language on a public highway. Okay? So they took good old Martin out of his house, put him in a cop car, drove on a public highway. Martin, obviously pissed. It's like, what the hell is going on? Whether he was rightfully arrested, wrongfully arrested. I mean, dude, it doesn't matter. If I'm in the back of a cop car, I'm like honestly upset. Okay? So he's using profane language, maybe some dams, some shits, okay, some crazy language, and for being drunk. And then he was subsequently charged for doing that on a public highway. And Martin was convicted under a state statute which held that any person who, while intoxicated or drunk, appeared in, this is a quote from the statute, any public place where one or more persons are present and manifests a drunken condition by boisterous or indecent conduct or loud and profane discourse shall, on conviction, be fined. Okay? So, at the end of the day, it's really just him being fined. Okay? He's not going to be confined to jail or prison, but he's going to be fined. Okay? And Martin, obviously pissed. Okay? He appeals this conviction. Okay? He is convicted in the state court, so he appeals it. And the appellate court essentially says that Martin did not intend, he didn't intend, he didn't actually try to be on this public highway. Okay, under the plain language of the statute, one being convicted of essentially being drunk in a public place must have put themselves there voluntarily. They must have actually done it. So, essentially saying you have to have actually done the crime, all right? He was arrested, taken out of his home, put in the back of a cop car. They drove on the highway and like, haha, see, look, you're drunk. You're saying bad words. But the thing is he didn't get on that highway voluntarily. I guess a more like extreme version of this would be like you're holding a gun, right? And you're holding a gun because you just want to see how it looks. And then somebody takes your hand and they put your finger on the trigger. And then they forcefully push your finger down and the trigger goes off. And let's say, I don't know, it grazes somebody. Assault, something like that, okay? You are not the one who actually squeezed the trigger. That's somebody pushing your finger down to squeeze the trigger. You didn't actually do the criminal act, okay? Hopefully that makes sense. That was Martin v. State. I thought that was kind of hilarious because, you know, I don't really know the background facts as to why Martin was taken out of his home and arrested at his home, but I'm assuming that he probably did something not okay. I mean, Martin probably shouldn't have done what he did, okay? But that doesn't mean that, you know, he should be fined for being on a public highway being drunk when he didn't actually want to be there. He was taken involuntarily, okay? That's the key word that the court loves to use. This whole word voluntarily. So that's the criminal act. You have to have actually done something. It's yourself. You have to have physically done it. Okay, mind control. I'm not sure if it works. I would say probably not. I would say if mind control does work, the court system might be in for a rude awakening. Because this criminal act, criminal intent, if mind control works, oh boy, yeah, that's going to be tough. By that point, I will be retired. And if I'm not, I will then retire. Because that's just, maybe I'll do defense work. I make it easier. I'm not sure. So, okay. We got it pretty much covered, right? Criminal act. Actus reus. You have to actually do the criminal act. If somebody takes your finger and presses down on a trigger, you're not the one pulling the trigger. That's somebody else, okay? Now, there's nuances to that, okay? We don't really need to get super far into it, but hopefully it makes sense that you have to actually do the thing, the criminal act. That's part one. That's part one of knowing what a crime is, what makes something illegal. You have to do it. So the next aspect to making something illegal, when something is bad, you're not supposed to do that. Murders, assaults, robberies, you know, the bad things, the things you're not supposed to do. Okay, we got the act down. Now we got to get to the intent. And this is, I don't know if this is the right word, but it's the word I'm going to use tonight. It's the fun version. It's the fun part of what makes something illegal. Because doing the thing, that feels pretty obvious, right? It feels pretty obvious. But criminal intent, the criminal mind, shout out to the TV show I watched. You know what? Okay, so Criminal Minds, right? I think that was kind of like the last TV show that I watched. That's like the prototypical TV show of like every episode there's like, you know, a crime that they have to solve and you solve the crime. But throughout the entire season, there's like this background story and then eventually they solve it at the very end. It's like literally the same cookie cutter mold TV show. And I think that was it. I think I finished like 2 seasons. I was like, dude, I cannot do this anymore. I can't do this anymore. So shout out to everyone that's finished all 37 episodes. I'm sorry, 37 seasons, or 38, 39. I'm not sure. They're probably approaching 40 at this point. 40 seasons of Criminal Minds. But let's get into actually criminal mind, the criminal mind, criminal intent, mens rea. Okay. Now, I don't want to get super law nerdy. I want to make this really basic. There's 2 different systems of what you can determine criminal intent. There's like the common law version, and we're not going to talk about that, okay? Some states follow common law, not the state that I'm in right now, and not the majority of states, okay? I believe California does. I believe Florida does. I don't know of any other states. I mean, obviously there's other states. And one of the big words in common law is malice aforethought. Okay? That should scare you enough. Malice aforethought? No, thank you. We're done. No malice aforethought immediately makes me walk the other way. Okay? So we're going to talk about the Model Penal Code. The Model Penal Code is a set of guidelines. They're not rules, set of guidelines that essentially explain what the criminal intent, criminal mind, mens rea is. There's 4 ways, okay? 4, okay. Just making sure I got that. I'm in law school. I'm not a math major, so math is sometimes difficult for me. Okay, so I'm gonna go from like most extreme to least extreme, and this should make sense. Okay, the first one is purpose. Okay, yeah, the criminal mind is purpose. Like I'm meaning to do this. Okay, I'm meaning to do this. Second one, knowledge. Okay, that means I know what I'm doing. Maybe I don't have the purpose to actually do the thing, but I know that I'm pulling the trigger on this gun. I know that that's what I'm doing, okay? The third, okay, like I said, math is not my thing, all right? The third, mens rea, if you will, okay? The actual law professors, if they ever watch this, are probably going to hear me talking and are going to be like, good Lord, what did I teach this man? But I can't be cold called right now, so that's good. Okay, I gotta stop rambling. Okay, third version of mens rea, okay, reckless, all right? Reckless. The final one, negligence, okay? Everyone knows that word, negligence, okay? Not gonna get really so far into what those actually mean. You can probably get the picture. You guys can Google. Those are the 4 mens rea. That's what most statutes use. Okay, so a statute will essentially write out the thing. It's like if you take the life of an innocent person and you do it with purpose, like that's kind of on the nose for a statute. Normally it won't be that obvious, but essentially you do something with purpose. That's, mental intent required to prove this crime, purpose. If you do something with knowledge, okay, you have the knowledge of what you're doing, then that's the mental intent required. If you do something and they say you're being reckless, then that's the mental intent required. Essentially, there's 4 levels of mental intent required in the Model Penal Code, and that is a majority of states, okay? There's some states where it's not like that. Let's stop talking about the boring stuff, okay? You guys got it. Now what we want to talk about is the cases. And these cases are honestly, the criminal intent ones are kind of crazy. So this first one that we're going to talk about is Regina v. Cunningham, which, believe it or not, okay, this is kind of crazy. It is not an American case. It is a case from the Queen's Bench. Queen's Bench. That means, to my friends across the pond, this came from you guys. This is from the UK. Kind of cool. So let's get into it. So the defendant, his name is Roy Cunningham. Roy Cunningham ripped off the gas meter in a cellar of an unoccupied home and stole money inside, okay? Now, we're going to have to visualize here, okay? Because this happened in God knows when, 1870 something. I can't remember exactly. But Roy Cunningham, the defendant, ripped off this gas meter inside a cellar of an unoccupied home. Unoccupied, no one was there. And he stole money inside, okay? That's what he did. Cunningham, the defendant, when he did that, okay, he didn't turn off the gas. We're all smart here. We're all smart. We can all see where this is going. The gas, because it was not turned off, because Mr. Cunningham decided to rip off the gas meter, okay, seeped inside to an adjacent house where, sadly enough, an elderly woman named Sarah Wade was sleeping. Wade was unfortunately asphyxiated in her sleep. Partially asphyxiated. Okay? So that means that she suffocated, essentially. Cunningham, the defendant in this case, pled guilty to the charge of larceny for stealing the gas meter and the money. Okay, so that makes sense, right? He physically did that. He physically took the money, and that's what he meant to do. That was his mens rea. There was intent behind that. Okay, But the question that you guys should be asking yourself is, well, wait, hold on a second here. Wade, the defendant, or no, I'm sorry, the victim in this case died. Okay, Wade died because of what Roy Cunningham did. So is there some law that he's breaking? He didn't mean to do that. He had no intent of doing that whatsoever. So is he doing something illegal? Well, you know what? Let's find out. So in addition, Cunningham was indicted under Section 23 of the Offenses Against Persons Act in 1861. That is actually something that the United States took. Shout out to our boys across the pond, the United Kingdom, which provided that it is a felony to unlawfully and maliciously give or cause another person to take poison in a manner that endangers his or her life, causing serious injury. So, in reading that statute, you're like, what's going on here? Give or cause another person to take poison in a manner that endangers his or her life. Okay, why is there a statute in the government written that specifically? Well, that's probably because this was a massive issue at the time, okay? It was probably an issue where people were constantly ripping off these gas meters to steal this money, and the government's like, hey, hold on a second here. We got to hold these people accountable, okay? So the statute provide that it was a felony, which makes it illegal to unlawfully and maliciously essentially cause somebody to asphyxiate and die. Okay, so what the trial court said was to the jury that the term malice in the statute meant wicked. Okay, why did the trial judge do that? I don't know. The trial judges, they can do literally whatever they want, and they are given very broad discretion when, like, a court of appeals listens to whatever the trial judge says. They're given pretty broad discretion, so they can really do whatever they want. Okay, and that's honestly, it's overall a good thing. Okay, so the trial judge instructed that the jury term malice in the statute meant wicked. Okay, so malice means wicked, and that a person acted maliciously if he did something which he has no business to do and perfectly knows it well. And perfectly knows it. Wow. Okay. So this is, we're reading text from 1875. I think I've changed the date 4 times. So because of that, Cunningham was convicted, and he appealed to the Queen's Bench. That is essentially Court of Appeals for the United Kingdom. I should not have done that accent. That was bad. So what did the Court of Appeals say? Well, the Court of Appeals essentially said that the term malice in a criminal statute meant that the person acted with an actual intention to do the particular kind of harm that was in fact done, okay? So that they meant to do what they did, okay? Did Cunningham mean to kill this woman? I don't think so. Let's figure it out. Or, second thing, or, not and, or, so it could be this opposite thing, reckless disregard of a foreseeable risk that the harm would result, meaning the person was aware of the risk of the harm and did the act anyway. Okay? Aware of the risk and did it anyway. In the United States, that's called recklessness. Okay? So if you ever see a statute and it says the individual recklessly caused serious physical injury, I don't know, I just made that up. That means that the defendant knew of a risk and acted anyways. Okay? So the court essentially said that there is no doubt that Cunningham, the defendant, that Cunningham behaved badly when he took the gas meter. Okay? There's no doubt that he did something wicked. He did something bad. All right? However, the real issue is whether Cunningham foresaw that taking the gas meter could seriously harm someone, but did it anyway. All right. Now, these cases that come up on appeal, any of my law school nerds will know that the real issues that come about are jury instructions, right? Jury instructions are like the crux of all of these cases that we read. And essentially, this conviction, okay, was quashed because of a bad jury instruction. However, The court said that the real issue is whether Cunningham foresaw that taking the gas meter could seriously harm someone, but did it anyways. Okay? Now, here's the thing. This was done in 1890, okay? 1890, right? If it's 2024, all right, and you go to, I don't know, wherever gas comes out of, I'm not some... Listen, I wear glasses, okay? That should tell you all you have to know about how much of a handyman I am. I wear glasses, okay? So wherever gas comes out of, if you go to that place and you undo whatever mechanism is holding that gas in, okay, I think it's pretty reasonable. I think it's pretty reasonable to assume that you would know, right? That you would probably understand that gas is going to come out of there, and gas, say it with me, ladies and gentlemen, gas is bad. Gas can kind of fuck people up. It can. Shocker. Shocker. So I would say that it really isn't an issue on whether the defendant, Cunningham, foresaw that taking the gas meter could seriously harm somebody. I think it's pretty obvious that could happen. Okay. Now, the only issue is he did it in an unoccupied house. All right. He did it in an unoccupied house. So is it reasonable to foresee that undoing a gas meter in an unoccupied house could harm somebody next door? Is that foreseeable? Well, I don't know. That's for the jury to decide. That's for the jury to decide. That's for the jury to decide if the defendant in this case actually had the criminal intent required. So I don't know. Maybe you guys can answer that question. I feel like I have my answer. You guys watching probably have your answer. Or you don't. And you have no idea what's going on. And then you are essentially me as a 1L in law school. Okay? So our next case is a case called People v. Conley. This is our last case. Now, when we talk about criminal intent, right? I'm going to give you two scenarios, okay? I'm going to give you two. First scenario number one, when we're trying to figure out criminal intent. Guy has a gun. Guy looks at individual, points the gun right at him, and says, I know what I'm doing. In fact, I am purposely shooting this gun at your face. And then the individual pulls the trigger of said gun and shoots the gun at the individual's face. Okay, that is a scenario where you can determine the criminal intent behind what somebody's doing based off of the words that they say. And that's great. If that happens in a court case, it's cut and dry. It's very simple, very easy, very obvious. Okay? Let me tell you. That happens never. Never? That happens never. It never happens, okay? And obviously it never happens, right? People don't speak their intent. I mean, unless they're lunatics. Maybe they do. Or unless they're really smart and they're like, okay, I'm going to be like, yeah, I'm negligently shooting this gun at your face right now. And then they're going to try to argue that it was negligent mens rea. I don't know. Maybe that's like 7 steps ahead. That probably is. That's probably just a much smarter thing to do. Point being, people don't say what they're thinking out loud. They don't, okay? So how do you determine that? How do you determine someone's mental state, someone's state of mind, someone's mens rea, the criminal intent behind it, when they don't actually say what they mean, okay? And that is where this case comes in. People v. Conley, all right? And People v. Conley, man, if we have any like frat bros watching or listening, listen up, my friends, because this feels like every freaking Saturday night in the summer. It just does. And my God, we hope it doesn't end like this, okay? So the defendant in this case, the defendant goes by William J. Conley. So William Conley, we're just gonna call him Mr. Conley. That's what we're gonna do. So Mr. Conley was charged with aggravated battery after he attacked the victim, in this case, Sean O'Connell. And he did this outside of a massive party that was going on. Okay. Let's just try to visualize this here. Okay. It's a Saturday night in June. It's like 70 degrees out. Massive party going on. And just outside, you got Mr. Conley, the defendant, who is in some sort of a fight versus Sean O'Connell. Okay. So Conley, the defendant, walked up to O'Connell's friend, this guy, Marty Carroll, and essentially demanded, required, said, "Give me a can of beer." I don't know if that's exactly how he said it, but it's just something like that. So he walked up to this friend of a gentleman that he would have a tussle with later in the night. It says, "Give me a can of beer." Essentially, give me a can of beer, right? And the friend said, "Fuck no. I'm not going to do that. I hate you. You're a loser." I'm ad-libbing right now. He might not have said all this stuff. He said no. He refused. He said, "No, we're not going to do that." And so Conley, right, did what any normal individual would do after you were rejected a can of beer. He takes a wine bottle and smacked Carroll across the head. And let me rephrase that. He tried to smack Carroll across the head. He took a wine bottle, like a wine battle? Wine bottle. Yeah, wine bottle. He took a wine bottle, okay, and pretended like it was a Louisville Slugger and went to smack Carroll across the head. Now, Carroll, on this Saturday night, 70 degrees out, right outside of a massive party, I guess had the reflexes of a god, okay? And he hit a quick little... Okay, so for everyone listening, I just ducked really fast. He hit a quick little... Okay? And you know, laws of gravity will dictate that if there's nothing to stop this bottle, it's just going to keep going. So that's what happened. The bottle kept going. Carroll ducked. And I shouldn't laugh, but it's just, some of these cases are so ridiculous. The defendant, Conley, ended up smacking O'Connell across the head. Okay? He literally didn't even mean to hit O'Connell, but he hit him. He did. Okay? And as a result, O'Connell sustained a broken upper jaw, lower jaw, and 4 broken bones. He lost one of his teeth and underwent surgery on 10 other damaged teeth. His damaged teeth are expected to last, they said, about 2/3 of his lifetime of his undamaged teeth. Why that's super necessary to know, I'm not sure. Other permanent injuries include partial numbness in one of his lips. Now, the reason the court really harped on all this stuff is because the statute talks about permanent disability and disfigurement as a part of aggravated battery. As I said earlier, these 2 gentlemen, I guess 3 gentlemen, were involved in a skirmish, and the individual who had the wine bottle, who smacked the other individual across the face, was charged with aggravated battery. And aggravated battery essentially requires disfigurement or permanent disability, okay? The other thing, it requires a person to intentionally or knowingly cause such injuries. Okay, so remember we were talking about statutes earlier? We were talking about, like, you know, the mental, the mens rea, the criminal intent, the mental state behind a statute. Well, guess what? In this statute, it requires a person to intentionally purpose or knowingly knowledge cause such injuries. Okay? That is the state of mind that is required to be charged and convicted with this crime. The trial court said that the defendant, Conley, was guilty of aggravated battery, and Conley appealed. Conley said, really? Really, guys? I didn't even mean to hit Conley. So, as I said earlier, the relevant statute requires that a person intentionally or knowingly inflicts permanent disability or disfigurements. So, the issues in this case essentially are, did the victim have a permanent disability or disfigurement? Let's just say yes, he did, okay? We got that done. Check, okay? Checked off. Now, we have to figure out if the defendant intentionally or knowingly inflicted that permanent disability or disfigurement. Okay? So the statute also helps give us some definitions of what those two things mean. The statute defines intent as having the purpose to do something, and it defines knowledge as being almost certain that something will occur as a result of an action. Okay? The court notes that although proving intent is hard, it is very difficult, courts can rely on the presumption that a person intends the likely consequences of his actions. Okay? That a person intends the likely consequences of his actions. So let's do a callback to the scenario I was talking about a little bit earlier, right? We were talking about a gun, someone pulling the trigger for you. Let's just pretend now, right, that you pull the trigger yourself. You have a gun, you pull the trigger yourself, okay? Now, instead of voicing and vocalizing, I am knowingly pulling this trigger and I am purposely shooting it at your face, okay? Let's say I don't say that. Those words do not come out of my mouth, okay? And you just pull the trigger and shoot at somebody and you hit them, okay? The courts can rely on the idea that when you take a gun and you point it at somebody and you pull the trigger, that you know what you are doing. You know that when a gun goes off in the direction of an individual, that you have some sort of mens rea, whether that's negligence, whether that's recklessness, whether that's just knowledge of what you're doing, or whether it's the most extreme purpose, whether you are intending to shoot somebody. Now, the court can rely on many, many different factors, okay? The court can rely, let's just say hypothetically, on your relationship, right, with the victim. Do you know the victim? Do you not know the victim? Let's say the distance between you and the victim, okay? Let's say I take a gun and I'm pointing it at somebody and I'm shooting and I'm a foot away, okay? Versus I'm 300 yards away, right? I'm 300 yards away and I'm just shooting a gun and I'm pointing it and I shoot and it hits somebody 300 yards away. Well, do you think that I had the purpose to actually shoot that individual? Maybe, maybe not. You'd have to look at the totality of the circumstances, understand everything that was going on. Well, that individual that's 300 yards away, do you think that I had the knowledge that when I shoot a gun in the direction of where people could be, that it's expected that somebody would die or somebody would be hit? Probably. But you would assume, right? You would assume. Maybe it depends on the landscape of where we're at. If we're in a city, okay, you could definitely assume that. You could definitely infer that. If we're in the middle of Kansas and we're in fields, maybe not, okay? But at the least, you'd assume it's reckless behavior or maybe even negligent behavior. Essentially, what this case is saying is that courts can rely and infer criminal intent based on the situation and essentially what is going on at this time, okay? So what the court said was that the defendant argued that there was not enough evidence to prove, beyond a reasonable doubt that he intended to cause or knew that he was cause permanent disability or disfigurements. And so then the court responded. The court said, however, judging from his use of a wine bottle, his lack of warning, and the force with which he hit O'Connell, it was reasonable for the jury to infer that Conley intended to cause permanent disfigurement. Essentially saying that when Conley took that wine bottle and swung as hard as he could, and swung hard enough to cause the damage that this victim suffered, it's okay for the jury, it's okay for me, it's okay for you to assume that he had some sort of criminal intent, some sort of mens rea. And in this situation, it's that he either intentionally or knowingly caused those such injuries. Okay? So that's it. That is essentially how you know if something is illegal. You have to actually do the thing. You have to do the criminal act. Somebody can't force you to do it. Somebody can't physically do it for you, and just your body is just a vessel, okay? And then you also have to have criminal intent. You have to have some thought behind what you're doing, all right? And when I say the words intent, it doesn't mean you have to do it on purpose. You could be reckless. You could be doing something reckless. Like, for example, right? If I'm driving a car and I'm on a highway, and I get off that highway and I go on a city block, right? And I decide I want to joyride. I decide I want to drive really fast. And I drive 100 miles an hour down the street. I drive 100 miles an hour down the street. And God forbid I hit somebody. I hit somebody with my car going 100 miles an hour down the street. And I said, Judge, I promise you, I did not mean to hit anybody. I just wanted to see how fast my car would go. The issue with that is that you knew, okay? You knew of potential risks, okay? You knew of potential risks and you acted anyways. That's recklessness, okay? Now, I could even argue, right? If we want to lower the mens rea, the mental intent, the criminal intent, you could say, I didn't know of the consequences. I thought it was 3 a.m. There was nobody outside. There was no one outside. And I didn't know of the consequences. But there were I didn't know of the risks. There were risks, and I still did them. Okay? So then me hitting that person, that's negligence. That's criminal negligence. So that's it. Wow. It was a lot, okay? That was a lot. Hopefully I explained this stuff decently well. And I also think it's just kind of fun, right? Maybe that's not the right word. It's just kind of interesting, right? And I really like doing all criminal law cases, right? This is more so what is a crime and the very basics of criminal law. Something that I think could be really fun is some criminal procedure stuff. So I plan on probably doing one of these, I say one a week. For all my listeners, I'm looking at the camera in a way that elicits the fact that I probably won't do one a week. I'm going to try my darndest, okay? I'm going to try my darndest. But I don't know if it's going to be possible. What I will say is, if there is any current criminal cases, if there is any current news in the criminal sector, I'm going to talk about it, okay? And I'm going to talk about it from the perspective of a law student. All right? Like I said, I'm a 2L law student. I don't have my JD. I haven't passed the bar. But God willing, I will get there. So, ladies and gentlemen of the jury, I felt like I needed to finish that statement with that. Ladies and gentlemen, this has been the first episode of Mike's Jurisdiction. I don't know if this is a podcast or a show. Or is a podcast a show? Or is a show a podcast? Now, these are the questions that I don't have time to Google. But you do. So I'm going to end it here. Hope you guys enjoyed. And I will see you guys next week for, I don't know, something related to criminal law. Goodbye.